I'd like to talk about the Fourth Amendment, which prohibits unreasonable searches and seizures, not all searches and seizures. And one of the things about the Fourth Amendment is to protect citizens from their government. So a couple things that it does. It establishes a privacy interest. It says that searches cannot be unreasonable. Searches must be based on probable cause, and they have to be very particular about what they are looking for. The way that someone would get a search warrant, a police officer, is that in their investigation, they would find what is called probable cause, something that would lead a reasonable person to believe a crime was committed by that person. And they would go to a judge and put a signed affidavit that that is what they are basing the warrant on. The judge would then give permission, assuming that the search warrant requirements were met. For example, if a police officer wants to search a house, they can't just say a house on Grant Street. They would have to say 431 Grant Street in whatever town it is, in Wilkes-Barre or Scranton or Hazleton, wherever it is. So they have to be very specific, and they have to be specific as to what they're looking for. Now I want to mention three different types, and you need to know this, and it's in the PowerPoint, but I want to give you the definition of them so we understand them. There are three types of police conduct with citizens, contact with citizens: a mere encounter, a stop and frisk, and then probable cause. A mere encounter is when people might be approached by a police officer. You're walking down the street, you're not doing anything wrong. Policeman comes up and says, I'd like to look in your backpack, and I look in your backpack. You really wouldn't have to answer. Reasonable suspicion is when a person is doing something that a reasonable person would think is suspicious. A policeman can approach them and can do a pat-down search where they would just go like this, pat them down to look for weapons. If they find contraband or a weapon, then they can make an arrest. Probable cause is the strongest. That probable cause is selling drugs to an undercover police officer, something that really shows a crime is being committed. An example of all this would be there was a case that we had that there were 4 students that were parked in an overlooking Penn State. There were 4 Lock Haven students. They were parked legally. It was almost sunset when the park closed, but it was still open. They were parked legally. They were the only car there. A police officer pulled up alongside them, no flashing lights. He just got out. He wanted to see if they were okay. He said that that's his normal, that's what he does normally. And what he did was he knocked on the window. And now that's a mere encounter. The driver could have just waved at him, didn't have to answer him, just said, "We're fine, thank you." But the driver instead rolled down the window and said, "We're fine. We're just here smoking some weed." Now, that immediately went from a mere encounter to probable cause, because when he put the window down, the police officer smelled the marijuana and then observed the drug paraphernalia. So reasonable suspicion would be, the famous case is when a man was trying to get into a bank, trying a bank door at 3 o'clock in the morning. There was no ATM, no people around. Police officer saw him and approached him, asked him what he was doing. He didn't really have an answer. The man was patted down by the police officer. Went all the way to the United States Supreme Court. The man's lawyer said the police had no right to even approach him. And the Supreme Court said, yes, he was acting suspiciously, and the policeman had the right to do a pat-down search to look for weapons. And the fact that he found burglar tools was okay. This is important. So you have to know mere encounter. You have to know reasonable suspicion. If it's reasonable suspicion, the police can do a pat-down search. Probable cause, and they can make an arrest. All right. Those are the 3 main types of police encounter. The key in looking at the Fourth Amendment is, what is a person's reasonable expectation of privacy? What is your reasonable expectation of privacy? I'll give you an example. If you're sitting in your own house you have the highest expectation of privacy. If you're out in public and you're talking very loud on your cell phone while you're walking down a mall talking about, come over to my house to buy some drugs tonight, 6 o'clock, and it's overheard even by an off-duty police officer, that's the person's tough luck. They have now given up their reasonable expectation of privacy. Doing something in public, like talking on a cell phone pretty loud. At a football game, a student yelled over to another one to come to his house. It was party 6 o'clock. There was going to be marijuana. Police overheard it, went and raided the house, and the police acted properly. Another reasonable expectation of privacy is in your car normally, but you do give it up by your actions, violating the motor vehicle code. Policemen have a right to pull you over. So if there is a reasonable expectation of privacy, the person's rights are higher. There are times when a search warrant is not needed, and that is, you need to know this, consent. As soon as you say, okay, if the police officer says, may I look around, and you say, okay, they do not need a search warrant. You have now given your consent. Another example would be, and this is all case-by-case basis. The courts have to look at the facts of each case. It's called exigent, E-X-I-G-E-N-T, circumstances. Exigent circumstances is to protect someone's life, for example, would be an exigent circumstance. So if a police officer gets a call that a neighbor hears fighting, heard a gunshot, gets to the house, hears some screaming inside, they can go in and make sure everybody's okay. But they have to have that almost like an emergency reason to justify not getting a search warrant. Cars are different because cars are movable, and police can stop you and detain you to get a search warrant if they have evidence to need to do that. However, and you'll see it in the news a lot, somebody's coming across Route 80, speeding out of New York, get pulled over. Policeman says, can I look around? Even though they have cocaine in the car, they'll say yes. And then the policeman, that's probable cause to make the arrest. The search is legal because the person gave consent. Another example, and this is a court case that I had in my court, where the police were doing legal profiling, not based on race or religion. They were looking for buses, people on buses that were coming out of New York, stopping at King of Prussia, Pennsylvania, and going on. And what they try to do is find people who buy their tickets in cash and are going, say, to Pittsburgh and then back the same day without any luggage or anything like that. That doesn't mean it's illegal. That's just a profile. But anyway, when the bus had a layover at King of Prussia, a lot of the people just sat on the bus. And before it left, two agents from the Attorney General got on the bus. And they did not have uniforms. They were coat and tie. And they said, we're with the Attorney General's office. Just going to ask everybody a few questions. That's a mere encounter. People don't have to answer. So they started in the back of the bus. They said, hi, how are you? You know, where are you going? Everybody answered. They said, yeah, we're going here. We're just coming from here. They got to a guy who was seated next to the window, and he had on brand new white Nike sneakers. And they noticed he was a big guy. His feet were big. And next to him was a Nike box that was enclosed. And they just said to him, is that your box? And the guy said, no. So they took the box, they held it up. Does this belong to anybody? Nobody claimed it. They opened it, and inside they found neatly packaged cocaine. And they found a receipt which had our friend's name on it. So his lawyer tried to say that the search was illegal, but what the court said was, once he said that that was not his sneaker box, that was abandoned property. And if it's abandoned property, the police did not need a search warrant. So the search was legal, and the guy was convicted. Now that brings me to, and we're near the end of this, but I want to tie this together. There's a rule, and it's in the book. It's called the exclusionary rule. Exclusionary rule. If the police seize evidence illegally, it is excluded from trial. It is ruled inadmissible, not allowed. That becomes very important. If a person is charged with possession of cocaine and the police found the cocaine illegally, then their lawyer could say that they would seek to have the charge thrown out, because if the court says, yes, it was illegal, police officer, you cannot tell the jury that there was cocaine. The charge goes away then, because you cannot be found guilty of possession with cocaine if the jury can't hear that there was cocaine, the illegal substance. One more example, real case. Police officer goes to a dorm room, woman's dorm, on a college campus, and knocks on the door. The girl that answers the door says, yes, you can come in. He wanted to explain that there were a lot of sexual assaults on campus, and he wanted to go over some safety precautions. He was sitting on that side of the room. The girl's roommate was out. He looked over on her roommate's desk and saw what looked to be marijuana, so he took it. And he had it tested. It was marijuana, and they gave a citation to the roommate, who wasn't there at the time. The roommate's lawyer tried to say it was illegal. The case had to be thrown out. But it was not illegal because the policeman was there legally, and he saw it out in plain view, and that's the last principle I want to mention. Plain view means if a policeman is in a place legally and sees something out in the open illegally, they can take it and use that to arrest somebody. So in this case, the policeman was in the room legally because the girl invited him in, gave him consent. The fact that it was on the roommate's side of the room didn't matter that the roommate wasn't there. Now, if the policeman had started looking through the roommate's desk drawers, for example, and found something, that's different. That would be an illegal search. The police officer would have needed probable cause, something to base it on, and then get permission from a judge through a search warrant. So to sum it up, make sure you read that chapter and understand the concepts I'm talking about, the important things about the Fourth Amendment. Know what a mere encounter is, what reasonable suspicion and stop and frisk mean, and then probable cause. I want you to also know that if you give consent, a search warrant is not needed, and please know what the exclusionary rule is. Thank you.